Me, sir, that the only contest between the two sides is not whether the appointment was made, but whether it required the approval of the assembly. Am I correct to say that?
You are correct.
Is it your case, sir, that that approval was not required?
It was not required. It was just a reappointment that has ever happened in other situations.
I will ask you, sir, to read the definition of appointment in the County Public Appointments County Assembly Approval Act. Chair, that will be at page 48 of our volume 2. Have you reached page 48, sir?
Yes.
Can you read for us the definition of appointment at section
2? For which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act.
So the law says an appointment for which approval is necessary shall not be made unless the approval is sought, isn't it?
It's true.
But you read section 4, you were ahead of me. I asked you to read the definition of appointment in section 2 on the same page. Please read what I asked you to read.
Appointment includes any reappointment to the same body where or not in the same capacity.
You will agree these sections, sir, show, contrary to the position you and the governor have taken, that this appointment which you concede was made actually required the approval of the assembly. By the law you've read, was that approval required?
It was required.
Good. If it was required, was it sought?
I need to emphasize on this through the chair.
Please answer my question. It's yes or no. You have agreed the approval was required. Was it obtained?
It can only be required when it is
yes or no, unless the chair rules me out of order. Was it obtained or not?
It was not obtained.
Good. It was not obtained. I will show you page 186. You just read the statute. We now want to see what the courts have ruled on the matter. Chair, I'm referring to volume 2 of our Bado, page 186. It's a decision, Chair, that begins at page 170, but I'm only interested in the conclusion the judge arrived at, which is at 186.
Honorable Chair, your kind permission. Yes, what is it? Honorable Chair, the concern is that this witness is being taken through a course to offer opinions on positions of the law. I think that is a matter for lawyers, and he should first of all have confirmed whether he tackles or handles matters of law in the office he said he serves in the county. Now he's being told to interpret a judicial decision, which, my Lord, may not be within his competence, because it's a matter of law, and any other witness, including the governor, would not have testified to that because it's not a factual matter. It's a matter of law. I think the witness is being oppressed to be required to offer a legal opinion. He has no training in law, my lord. Thank you.
Counsel, don't overprotect your witness. Your witness is a very competent man. I think what the counsel for the county assembly is asking for is not a point of law. He's not even seeking an opinion. It's a fair question. Let the answer be on record. We shall interpret it. Don't overprotect him. He's above 18.
Most obliged, sir.
Through the chair.
Even asked you the question, sir. Please read for us paragraph 105 on page 186. It's a matter about a county assembly appointment, just like the one now before us. Please read it.
Paragraph
105, 105.
It was, however, contended that since some of the petitioners had been approved by the previous assembly as the first respondent and its predecessor were exercising authority as the trustees of the people of Kenya, and more specifically the resident of Machakos County under Article 73 of the Constitution. It was thus surprising how the same constitutional body can arrive at two different reports on the same nominee for a similar job description. This issue brings to force the question as to whether the county assembly differently continued from this previous one is
I think it's constituted, sir, not continued, unless it's
constituted from the previous one is bound by the decisions made by the previous assembly in approving the nominees. If this position was true, it would mean that those who were serving in the previous government would automatically qualify for approval by the assembly once nominated by the governor. With due respect, if this was the intention it would have been precisely stated in the registration. This court cannot lean in such a drastic proportion of law which is not expressly provided in Alfred Mahandi, Ngome, and others versus George W. Sitati and two others, civil application number NAI 268 of 1999. It was earned that.
You can even leave it at this, sir. You will therefore have to agree whether it is by reading the statute or reading the case law. The appointment of Rufus Miriti required the approval of the assembly. Now that we are not in contest, the appointment was made.
That's what I want to make clear.
Now the question, would you agree, sir? Would you agree based on the case law you've just read, based on the statute you just read, that contrary to the position you've taken, this specific appointment was illegal for want of county assembly approval?
I want to make this through the chair.
Please answer my question, sir. You will get the opportunity.
Order, counsel. Relax completely. I think the witness wants to help us. Just allow him to address the chair. Witness.
Through the chair.
Chair.
I want particularly to mention the issue of Rufus Miriti. Rufus Miriti was the county secretary for the previous government. That is the former government. When the current governor came in, she extended his term to complete the handing over that was taking place. In all the situations that you've faced, for the county secretary, who has been the custodian of the former government, you just extend some time for him to continue serving so that you can get all the resources, all the requirements, or anything that you need. And that one is allowed by the county secretary being the secretary of the transition committee that is always there to ensure that there is a smooth transition from the older government or from the former government to the current government. That is what happened. That's why there is no appointment letter for Rufus Mereti that is available, because the extension was for, that's not a reappointment, but extension, so that that time will allow the governor to form the government, and thereafter appoint a substantive county secretary that will be forwarded to the assembly for approval. That is the case. There is no letter. Is an extension that is allowed even by the transition authority, whereby the county secretary is the one that is in charge of handling matters before the governments are formed.
This idea you are now introducing from the witness box.
Counsel,
Yes.
I think the witness wanted to help us. You are helping us. Now you've boxed yourself. Do you have a letter showing that that extension was given?
The witness has confirmed, and the documents filed on the record show it is common ground. The appointment was made. What is not agreed is whether that appointment required the approval of the county assembly. The clarification the witness is now offering from the doc that this was a transitional arrangement. That is not the position taken on the pleadings. That is not the position in his affidavit or the governor's affidavit. It is a completely new position taken from the witness box, but not from the pleadings.
Chair, yeah, I sympathize with my classmate, but counsel, that is a problem you have brought upon yourself. Because after reading to the witness the law, he is on record saying that yes, this is an appointment that required parliamentary approval or the approval of the assembly. Why you then pose the question again to him is something I don't understand. But here perhaps to guide the process, because the witness has alluded to a specific time, let him tell us or tell the committee how long this appointment was and where we can find that detail in the documents that are before us.
Let the witness respond to that. We don't confuse him too much, then I'll allow you to.
Through the chair, for any acting, acting county secretary, provided that he qualifies or she qualifies to act under that capacity, you're given 6 months by law.
Yes, Senator Wandako.
Chair, I just wanted a clarification. Is the county secretary being appointed to act the county secretary that was serving in the previous term, or is a new officer?
Through the chair, is the one that was in the previous government.
My next question, Chair. County secretary served for a fixed term of office on appointment. Had the contract by the time the new county government of Meru came into office expired?
No, it had not expired.
So what was the necessity for reappointment?
The contract was for 5 years. That was expiring actually on 19th of next month. That is the time that is supposed to expire.
Robert?
Yes, Chair. I just needed to get to know benefit of experience. Senator Madnago has picked on the issue. I needed to ask for clarity. Currently, is that county secretary still serving?
Yes.
Has the same county secretary in question is the current county secretary serving, right?
Yes.
And within the contract term. Is that the case?
Yes.
Okay, then what was the purpose of extension of the contract as you've discussed in that case? Because if the contract was current for the county secretary and is still serving up to now because that contract is current as per the information you've given, then what was the purpose of giving another letter of appointment or an extension for that matter?
There is no letter that was given through the chair. It's only that Her Excellency Governor confirmed through mentioning the name that because he was serving the former regime, or the former government, he is going to continue working with the current government. That's just what happened. There was no letter of appointment.
Thank you. Counsel, your witness is ahead of you. If you intended to puncture his evidence, you've made him to read the law. He has read it correctly. You have asked him how he interpreted it. He has interpreted it correctly. So you just abandon that and go to the next point.
Because the position the witness has taken on the doc, I told you, is not what is on the documents.
Oh.
I want to show him the documents. Please look, sir, at page 62 of our volume 1.
Yes, I'm there.
62, chair of our volume 1. The pagination is falling on a blackened area, so it's the page after 61. That's a post by the governor, sir, right?
Yes.
Does that post indicate anywhere that the appointment of Rufus was on transitional basis? It's either yes or no.
No.
We played videos yesterday, and Chair, those videos will be Annex 3 and Annex 3A. The transcript will be at page 53 to 54 of our volume 1. In the video utterances, which we don't dispute, were made, was any clarification made that the appointment of Rufus was on transitional basis?
It was made, it was not made.
Good.
And through the chair, on the same
You have
strength.
answered my question, sir, but if the chair permits, you have no problem.
Yes, through the chair.
Order witness. Why are you volunteering information nobody wants? You've answered your question, wait for the next.
There are some appointments, sir, which we claim were of unqualified persons, including Hilary Sadi, right?
Yes.
To what position did you tell us Hilary Sedi was appointed?
Director of Communications.
Director of Communications.
Yes.
I want you to take you through the governor's documents. What was your explanation, sir? If I remind you, your explanation was just like your post as Chief Secretary. This appointment did not require the approval of the Assembly. Is that still your position?
Yes, it's true.
Please confirm Sandi was appointed at the level of directorate.
I confirm.
So this is a man who is in charge of a directorate in the Assembly, or rather in the county government, the executive side that is.
I
Correct?
confirm.
You confirm. And as a matter of fact, your testimony was that we were erroneous because the advert we are referring to is for a junior position, isn't it?
Pardon?
Didn't you tell the committee that the document at page 76 of the Governor's Volume 2 is for a position that is subordinate to the position Sadi occupies?
It is true.
The Governor's Volume 2 Chair. It is true. Please confirm from this advert that the advert comes not from the office of the governor, but from the County Public Service Board.
That is true.
Confirm as well that the advert invites positions for several directorates within the county government of Meru.
That is true.
Please confirm one of the directorates is at page 67.
That is true.
The other directorate is at page 68 of the advert.
That is true.
There is yet another directorate at page 70, number 5.
That is true.
There is a deputy directorate, now not the directorate, at page 71.
That is true.
There is a directorate at page 73.
That is true.
There is a directorate at page 75.
That is true.
And your testimony in chief was that the position at page 76 is one pack below the directorate. Isn't it?
Yes, it's true.
Sir, I put it to you that it is self-serving for you to claim the directorate that Sadi leads is in the office of the governor, when all the other directorates, the recruiting agency, is the County Public Service Board. You cannot be a witness of the truth.
I'm witness of the truth. I produced the documents that shows Director of Communication specifically is under office of the governor. Like the case
Which document was that? Please refer us to it.
I'll refer to document page 83 of the volume 2 of the governor's response. That is one of the positions the Director, Governor's Press Service, or Director of Communication, that is one of the positions that has been put by the Intergovernmental Technical Committee, which took over from the Defiant Transition Authority.
Sir, are you aware you're referring to a different job description? This is Director, Governor's Press Service. That's not the position Sadi was appointed to.
That is the same position. Is where, for example, you can mention the position of Chief of Staff and the position of Private Secretary. That is the same position.
Chair, so that we don't have an altercation, I'm inviting you to note, because by law documents speak for themselves, from the video, from the adverts, it is Directorate of Public Communications, and the explanation the witness is offering is a completely different job description.
Continue. We've seen it on page 83.
Sir, you will also agree with me that in this advert, all persons called to apply for either directorate level or deputy directorate level must have a minimum of 5 years experience.
That is true.
You will also agree with me that Hilary Sandi does not have a minimum of 5 years experience in public affairs.
As I indicated,
either you agree or you disagree, sir.
I don't agree on that.
Good. We've had your answer, but I put it to you. Neither you, nor the governor, nor anyone has placed material before this Senate to show Hilary Sandi has 5 years experience in public affairs.
Through the chair, my responsibility from the office of the governor was to forward the name of Hilary Sandi to Public Service Board as required by law. The Public Service Board is the one that was supposed to determine whether Hilary Sandi has an experience of 5 years or not. When they give us a feedback that Hilary Sandi is qualified to be appointed as the Director of Communications, we did that.
Let's go to the other illegal appointments, sir. Would you agree that all county public offices are regulated by a law?
I agree.
You will agree that if an office is to be created that doesn't exist, the mandate lies with the County Public Service Board.
Not always.
Not always.
Yes.
Sir, is a governor entitled to establish informal structures that are parallel to those that are known to the law?
No.
Good. If the law has established a body to deal with a particular aspect of public governance, is the governor allowed, whether formally through the videos we saw, or informally through the letter you say we don't have, to establish parallel structures?
She is not allowed.
She's not allowed. Would declaration of informal holders, when they are official holders of the mandate in question, undermine the functions of the persons who lawfully are empowered to discharge that function?
Through the chair, the three positions that you mentioned have never heard even the governor talking about them in public or elsewhere. It is the removal motion that mentioned those positions in the motion that we are in. So,
Sir, that was not my question, and I don't want to have an altercation with you. My question was whether the establishment of parallel institutions to those known to law would undermine the discharge of the mandate of the official institutions known to the law.
Yes, it is.
Therefore, you will agree, even if we were to accept for argument's sake that there is no appointment letter, the informal declarations whose existence is not in contest was still a usurpation of the statutory and constitutional functions of the bodies mandated to deal with the various issues in the impeachment motion.
Through the chair, it is my evidence there is no informal declaration of any appointment for an existing office so that you can have parallel offices. Throughout the motion that I've read, throughout the response that I've gotten from the council or from the county assembly, there is no such declaration, whereby we have in contest of two parallel offices that are in existence. I have not known of that unless it is produced before this committee.
You are the chief of staff, sir. That's an official position, isn't it?
Yes, it is.
If the governor appointed an informal through a kamukunji or public rally, an informal chief of staff who has no appointment letter, wouldn't that interfere with your official functions?
If it is,
as
it
the
can.
legal chief of staff?
Order, counsel. Counsel. In his evidence, the witness has attached documents, evidence, confirming that those so-called appointments, they never got appointment, they are not on the payroll, the positions they were purported to have been appointed to don't exist in the county government structure. Why are you belaboring when we have so much to deal with? Why don't you...
Chair, I had not gotten to that dynamic of the problem, but I can go to it now that you direct me. Let's start, sir, with all the letters you supposedly wrote to various bodies asking to confirm. And Chair, just to answer your concern, that what I was trying to show the witness is, even if they were right on the facts that there was no appointment letter, it will still be a usurpation of the official functions.
Through the chair, I also want to confirm we went ahead and give the names, the letters of appointment of those that are currently holding the offices that have been mentioned. We revamped on that, and through the response of the governor, we've attached those are currently in those offices.
Let's look at the letter at page 51 of, Chair, I'm referring to page 51 of the Governor's Volume 2. That's a letter by Virginia, sir, isn't it?
Yes.
Has Virginia sworn any affidavit before the Senate?
No.
Has she recorded any witness statement
No.
before the Senate?
No.
This document, sir, what is the date on it?
It is on 23rd of November 2022.
And was this before or after the impeachment motion?
It was before the impeachment. It was after the impeachment motion.
Have you read the date of the impeachment motion before the Senate?
Yes.
It is 5th December. So this date, is it before or after?
It is before.
It is before. You will agree with me, sir. This is a document in response to a memo from you.
Yes,
So your memo equally, the memo being responded to, must have been in existence before the impeachment motion.
it's true.
Did you place that memo before the county assembly?
No,
Did you place this letter at page 51 before the county assembly?
no,
Sir, the answer you have given me, the two last answers, you will agree with me those answers apply to the document at page 53, correct?
it's true.
Those two answers also apply to the document at page 54, correct?
Yes,
The one at 55, correct or incorrect?
it's correct.
When we come to the one on page 56, you will agree it is a document generated on the day, a day after the impeachment has taken place.
It is true.
So this is a document, sir, made after the event.
It is true.
You will agree with me, the same applies to the document at page 57. It's made after the event.
Correct?
At your instigation, sir, isn't it?
Yes.
The one at page 58 was available long before the impeachment, correct or incorrect?
It is correct.
But it was not placed before the assembly.
Through the chair,
Either it was or it was not.
through the chair. Remember, an issue was discussed and we didn't, or the governor did not do a response to the county assembly of Meru because the advice was given by the legal to the governor. So there is no way that this document that the council is mentioning
I'm waiting
I'm
for
saying
you to finish
through
your
the
answer.
chair, I've seen the chair is consulting. I've saying all these documents that the legal counsel is mentioning were not forwarded to the county government of Meru because the legal advisor, the legal team to the governor advised that the governor was not going for the impeachment motion that was in the county assembly. And there is no way the question that the legal is asking, there is no way these documents now could have found their way to the county assembly when there was an advice that the governor was not participating in the motion that was in the county assembly of Meru.
Chair, or rather, Mr. Witness, we are not interested in the legal advice. The legal advice you received is in any event privileged, so we can't even insist on seeing it. My question was simply whether the document was presented before the assembly.
The governor did not attend the impeachment motion at the assembly.
Was she availed the opportunity to present not just this document, but indeed all the documents before the assembly?
She could not forward the documents.
That's not the question. Was she availed the opportunity to present those documents? Now that we agree all of them were in existence, was the opportunity given?
The opportunity was given.
Good.
But she underlined.
We are not interested in the buts. You will have the opportunity to say the ifs and buts in re-examination. Let's go to the document you said it was before the impeachment motion at page 51. Do you know when was the date of the first impeachment motion, sir?
Yes.
What was the date?
It was on that 8th.
It was actually 21st. That year there was the debate, isn't it?
Yes.
Therefore, you will agree, even this document at page 51 was made after the event. Never mind, the event was quashed by the High Court.
I agree.
Order, order. I think the counsel for the governor, I don't know whether you're following this matter. Why is the counsel for the assembly interrogating your client on a matter which is not before this committee? The matter of the first impeachment is not our case here.
Chair, I'm guided. I'll just withdraw the question so that we don't take.
Be fair to us.
I'm guided, Chair.
So far, we have gone so well with you, with us, and with the public. Let's give it the seriousness it deserves. We give the people of Meru justice.
My apologies, Chair. Sincere apologies.
Lukumba wacha.
There is the document by Geoffrey, Edward Budi Geoffrey, at page 105. Correct, sir? Page 105 of the Governor's Volume 2.
Yes, it's there.
As a matter of fact, Geoffrey has sworn two affidavits, this one and the one that is signed.
Yes.